Call number 21-50060, United States v. Minjarez. Mr. Smythe. Smith or Smythe?
Smythe, Your Honor.
Smythe.
Good morning. May it please the court. My name is Peter Smythe, and I represent Adam Minjarez. The crux of this appeal is the district court's conversion of half of a pile of cash found next to another pile of marijuana, the conversion into cocaine, 50% cocaine and 50% marijuana. The government conceded that this conversion ratio at sentencing was speculative and arbitrary. And I think that's telling because the defendant's objection was not the conversion itself, but the conversion into cocaine. And so the defendant's objection was, we will concede conversion into marijuana. And then the government at sentencing says, well, district court, whatever you do with regard to a ratio of cocaine is going to be arbitrary and speculative. Two things I'd like to emphasize in our argument today. One is in the PSR, it's paragraph 5, ROA 147-48. The PSR says this. It said, Minjarez was known by law enforcement to distribute various narcotics and broadcast the narcotics on social media. There's nothing that backs up that statement. The PSR does not say how law enforcement was aware that he was distributing various narcotics. There's no evidence of surveillance, no evidence of controlled buys.
I thought hearsay is permissible in pre-sentence reports.
It is permissible, Your Honor, but this is what I would say a vapid statement. To say that law enforcement is aware that he was distributing various narcotics, well, where's the evidence backing that up? It looks as if the probation officer just talked to an unidentified law enforcement officer who was summarizing just some information that he might have seen.
Were you his counsel at trial?
No.
Oh.
No, I'm just appellate counsel.
I'm just wondering, why did defense counsel allow him to plead guilty to distribution or possession of cocaine? Well, it's distribution, right? Possession with intent to distribute cocaine?
Yes, that's what he pleaded to.
Well, why is that PSR statement necessarily inconsistent with that?
Well, the PSR statement said he was known by law enforcement to distribute various narcotics.
Well,
it doesn't say that he... I'm sorry.
Cocaine is a narcotic.
Yes, but he was in possession. This statement goes to broad distribution, and also it goes on and says, and broadcast the narcotics on social media. So this statement is separate and apart from the arrest, the happenstance of the arrest. And it is used by the probation officer in the addendum to say that the entire record as a whole makes it plausible that the conversion ratio should be 50-50. And just going back to that statement, it says...
Counsel, was there any evidence that he was a user of cocaine as opposed to a user of other drugs?
I think the PSR says that he tried cocaine once, and that was it. And the government, in its brief, made the argument that the cocaine that he has was for distribution based upon that statement that he used cocaine once.
Well, how many grams of cocaine did he have?
He had 36 grams of cocaine when he was arrested and 5 grams of cocaine in the trailer that the agent searched.
So if he's not a user of cocaine, certainly not a habitual user of cocaine, that's certainly plausible that he's a distributor of cocaine, isn't it?
That's true, yes. But that doesn't answer the question of money found next to a pile of marijuana. When one goes to Application Note 5, which U.S. v. Berry says is the sole authority of converting cash into drugs, the court is supposed to look at financial records, transactions, and out of transactions, I would say distribution patterns. There's no evidence, or the government did not present any evidence of where this cash came from, how it was connected to cocaine at all. In fact, that's what the trial lawyer's objection was at sentencing. There was no analysis done. And when after that objection was done at sentencing or to the PSR addendum came out, and it still didn't have any analysis of how it got to this ratio. What you see in the PSR addendum is you see a paragraph citing application note 5, and then there are 2 paragraphs of case law with this court, just with the fact that this court or courts can convert cash into drugs. And then the very next line, the probation officer says, in Minjarez's case, it is plausible in light of the record as a whole, which is an appellate standard, the monies located were proceeds from the sale of marijuana and cocaine. It's like, well, there was just no analysis at all. The only thing that we could find, and I think I mentioned it in the reply brief, is because there were 2 drugs involved, it was okay to split the money 50-50. But that cuts against application note 5, because if there's going to be a conversion of dollars into drugs, then there needs to be some kind of evidentiary support for that, whether it's financial records, drug ledgers or the rest, whether it's surveillance, whether it's controlled drug buys, whether it's you could have undercovers with reporting of trafficking and that kind of thing. But this record is devoid of all of that. And in fact, that was pointed out by trial counsel. It's like there is no analysis. And I think that's reflected by just the government lawyers going into sentencing and telling the district court, whatever you do is going to be arbitrary. Yeah. And that arbitrary nature cost Mr. Minjarez 8 levels in his advisory guideline range.
You don't deny, I take it, that some conversion into cocaine from the proceeds would be plausible in light of the record as a whole?
No, we don't concede that, Your Honor, because...
You don't concede. So you don't think it's plausible to convert any of the money into cocaine, given that you just told me he's not a cocaine user, and yet he had 40 grams of cocaine?
Because the question is, you have this pile of money next to marijuana.
Is it really determinative that it was next to marijuana?
Well, it's in the same warehouse. They found cash and marijuana together.
Just because it's found with marijuana, it's implausible to say that the proceeds came from the sale of any other drug?
I think so. When you look at U.S. v. Berry, the simultaneous discovery of cash and drugs lends itself to conversion into that drug.
There is no law that says the theory. I appreciate your position as court-appointed counsel, but you can't cite a single case that prevents a district court from converting into one or more drugs when the defendant is in possession of multiple drugs, or assessing basically whatever is reasonable. And it just seems to me the biggest point against your argument is he pled guilty to a cocaine offense.
Yes, but pleading guilty to the cocaine offense, looking at the offense, the arrest was somewhat happenstance. Officers were conducting a traffic stop of somebody, and then Mr. Minjarez's girlfriend flew by, and they stopped that traffic stop and then performed the traffic stop and arrested them.
Well, what's a non-happenstance traffic stop?
Well,
I mean, this is what every traffic stop is that yields drugs. Very few of them are with the direction that there's quite sometimes suspicion that a certain vehicle may harbor drugs, but this is just someone speeding by, and turns out they've got a hidden compartment, and they just came over the border 3 days ago, and he has a long record, criminal record, so it's not happenstance.
Well, let me discuss that criminal record, because when one goes back to his criminal record, it's all about marijuana. There's no mention of cocaine whatsoever. And in fact, there's only a 2017 conviction where there is something other than marijuana, some unidentified pills. So going back to this paragraph 5 in the PSR says he was known by law enforcement to distribute various narcotics. Well, what are those narcotics? They're not identified. Do they include cocaine? We don't know because it's just a vapid statement. It's a conclusionary statement that the district court erred in relying upon in doing this conversion to cocaine. And looking at, to go back to your question, Judge Duncan, I think the proper analysis is if law enforcement finds cash next to a particular drug, then the conversion would go into that particular drug unless there's some other evidence showing that that pile of money, in this instance, came from some other drug. If there were some other transactions supporting this, if there was some kind of surveillance about cocaine and that kind of thing, we make the argument in our brief that there's no evidence that Mr. Minjarez was using this warehouse as a bank for all of his activities. There's just no evidence of it. And so it comes back to, okay, the district court could convert the pile of cash into marijuana. That was conceded by Mr. Minjarez at sentencing. But where is the evidence showing that any of it came from cocaine distribution? There just is none.
May I ask a question? Why is he incarcerated in the TDCJ instead of federal prison?
I'm not sure, Your Honor. I'm not sure what those pending charges are for Mr. Minjarez, since I wasn't appointed on those charges.
Okay. That suggests that there's something else that he did. So.
Well, on that 2017 conviction, I think there was a revocation. It's noted in the PSR that I think revocation was pending, and that might be the reason why. So if there are no other questions, I'll give my time back to the court.
Okay, you have time for rebuttal. Thank you.
Thank you.
Ms. Berenguer.
May it please the court, Elizabeth Berenguer for the United States. The court was required to approximate the drug quantity if the seized quantity did not reflect the scale of the offense. And here the court plausibly concluded that 50% or half of the drugs should be attributable to the cocaine. And for the reasons that Judge Duncan brought up and Judge Jones, that the defendant pleaded guilty to possession with intent to distribute cocaine. He was found with distributable quantities of both upon his arrest, and the social media accounts showing that he was a distributor. And that's not only from the PSR. The factual basis also makes mention of those law enforcement reports, and that's on ROA 31. So from this, the district court plausibly concluded that at least some of those drugs should be allocated to cocaine. Consistent with Martinez, this court's recent decision in Martinez, the court did not allocate it all to cocaine, so it's actually consistent with this court's precedent. And as far as how the court allocated it, I just remind the court that the defendant never raised that issue below. The defendant never raised the sort of how much should be allocated to cocaine versus marijuana to the district court. He merely said that it should all be allocated to marijuana. So the issue was not presented about this argument about the ratio of how much it was in his inventory.
Well, I think he's arguing essentially the same thing up here. He just disclaimed that there should be any allocated to cocaine.
Yes, but to be fair, in his brief, he did say alternatively, the court could have done it based on the inventory, and we're merely saying why that could have been one way the district court did it. It doesn't mean it's clearly erroneous for the court to have taken a different path. And in fact, that sort of inventory-based allocation isn't really that helpful to us in a case like this, where someone stopped in a car and we don't have any evidence of historical sales. I mean, it may make us feel good that it's tied to a methodology of inventory, but in that sort of without any sort of sense of, how fast he sells one versus the other, or any sort of information about historical drug sales, inventory alone isn't really that great a measure. Another way that the court could have done it and sort of turned out with the same guideline range is the way that the Sentencing Commission compares different kinds of drugs, and that's through converted drug weight. And so if we take all of the drugs that were found both in the storage shed and in the house and in the car, and we turn it all into converted drug weight, it ends up being a 60-40 marijuana to cocaine ratio, which is pretty close to what the court found here, which is 50-50. And 60-40, if you convert that all and account for both the marijuana and the cocaine, it ends up being the same guideline range. It's 102, which is 100 to 400. So even though the court didn't consider a converted drug weight, that would have been an appropriate way for the court to do it, and it would have resulted in the same guideline range. Let me just see if I had any notes here from... And I just did want to point out the record site that shows, sort of supports the idea that the cocaine allocation that was for distribution, and that's on ROA 176, that he was not using that cocaine. He'd only reported using it once in the past. So from that, the court could plausibly conclude that he was distributing the cocaine and that the proceeds were from there. And if the court doesn't have any further questions from me, I would ask it to affirm the sentence and judgment.
Well, I guess we don't. Thank you. Mr. Smythe, rebuttal.
Yes, just one or 2 points, Your Honor. First of all, with regard to Martinez, which was part of our Rule 28J letter, this court found error based upon the ratio, and Martinez, the error was because the district court applied a ratio that did not go to the location. Martinez involved a store, and the district court did a ratio based upon controlled cocaine buys in the store, and so the probation officer went that way, kind of like this way in the conversion ratio. And this court said, well, the Martinez court said, well, that's wrong, because there were more than cocaine was being sold from the store, and even legitimate sales were, so the ratio was all wrong there. The point I want to make is, in this case, we have a warehouse with cash and marijuana in it, and our argument is, well, you convert the cash into the marijuana because that's where they were simultaneously discovered. And that's the same kind of analysis done in Martinez, where in Martinez, it's like, no, do the ratio based upon the drugs that are all sold in the location, not just pick and choose. And then the second point is just about converted drug weight. Well, the probation officer didn't do any converted drug weight in this case. The probation officer just calculated cocaine and nothing to do with marijuana. There's no converted drug weight in the analysis here. And so that comes back to the sentencing was driven by this, what the government again called arbitrary ratio, cocaine ratio, all the way through to Mr. Minjarez's advisory guideline range. That's all I have. We would ask that the court vacate the judgment and remand the case for sentencing.
All right, thank you, sir. And you are court appointed, and we appreciate your using the resources to come over here to argue the case.
Thank you.
You did a good job. Thank you.